The United States is a nation that practices capital punishment. What exactly does that mean? When an individual is convicted of a crime, a sentence recommended as punished is to die by lethal injection, hanging, the electric chair, or the firing squad, that individual has been given the death penalty. But this is not a sentence that is carried out immediately or even in the near future. What I would like to discuss today is should the justice system review and change parts of the death penalty. An individual that is sentenced to the death penalty is transferred to a facility where they can be held in a safe environment. Imagine that. They get a safe environment after they have committed such a horrible crime, where the individual can be isolated from other prisoners. Their cells are usually very small, and they are only allowed very short periods of exercise, and visits are closely supervised. In the United States justice system, a death row prisoner has a legal right to a number of appeals. The exact number of appeals varies depending on the offense. In several instances, a prisoner can wait on death row from 20 to 30 years as they exhaust all the appeals they currently have the legal right to file. Many death row inmates will die of natural causes rather than the sentences they were given. A death row inmate has the right to file a series of at least 4 appeals. The first is the direct appeal, which is brought before the State Court of Criminal Appeals. This court reviews the sentence to affirm or vacate the sentence. If they choose to vacate the sentence, then this inmate goes back to court for a new sentence hearing. The second appeal is the state habeas corpus. This is an appeal that allows the inmate to have the sentence reviewed to see if he should be lawfully imprisoned. Did you hear me? The purpose of this appeal is to see if the inmate that has been found guilty of a capital crime and sentenced by a jury of his peers should be imprisoned. The third step is the federal habeas corpus appeal. In this court, the defendant argues for their sentence to be overturned because the conviction was a violation of the defendant's federal constitutional rights. The fourth appeal is the United States Court of Appeals. The sole purpose of this appeal is for the losing side of the federal House corpus court hearing to determine if that court made a wrong decision. There are currently 35 states that still have the death penalty in effect. The total of executions between 1993 and 2009 have been 1,000, compared to the 4,144 death penalty convictions. Keep in mind, the 1,000 executions stated above were none of the 4,144 sentenced criminals. A death penalty can cost the taxpayers anywhere between $2.3 million to $186 million, depending on the state where the inmate is housed and how long it takes for the inmate to exhaust all of his appeals. There. Now you have the facts and figures about the death penalty convictions. Now I ask you, when a person is sentenced to corporal punishment and there is no doubt this individual is guilty of that crime, why should we, the taxpayers, pay up to $186 million to house and support this individual for the next 20 to 30 years? Let me give you this case review. Brian Dwayne Brookins was convicted of murdering his wife and stepdaughter in 2005. It took 2 years for him to finally go to trial. October 15, 2007, he was convicted and sentenced to the death penalty. Only 2 years and a day after he killed his wife and stepdaughter. His stepson was the only survivor, and he will be between 27 and 37 years old before this sentence might be carried out. The victim's parents and grandparents will more than likely go to their graves, never having closure, never seeing the man guilty of killing their child and grandchild be served the sentence he was given. Yet this man only took 15 minutes to murder his wife and stepdaughter. And it is this part of the death penalty that so urgently needs to be revised. Why should the only surviving child and brother to these victims have to wait 20 to 30 years to have closure to the loss of his mother and sister? Mr. Brookins confessed to the crime. There was hard, substantial evidence and witnesses. There was no doubt he committed these crimes. He should not have the right to any appeal process. His sentence should be carried out within 90 days of the sentence hearing. Why should we, the taxpayers, pay millions of dollars for his support? Granted, there have been some set free because evidence re-examined showed beyond doubt they were innocent. You will find in these cases the evidence and reasonable doubt. The accused did not confess and maintained their innocence. For these cases, yes, an appeal process should stay in place. However, not the current appeal process. There should be a check and balance system in place to make sure what the courts are handing down is correct. It should be an appeal system that reviews and questions the evidence and testimony presented in the first trial. There should be an opportunity to carefully examine all pieces of documentation used to render a guilty verdict. The jury notes should be examined. Questions such as, did all the jurors vote guilty immediately, or did they all have to deliberate to convince some jurors to change their vote? If so, what evidence either convinced them or what evidence were they hung upon? There would be money well spent instead of questioning the decisions of the appeals courts. The United States needs to examine the appeal system practiced in other countries. For instance, in Japan, inmates are not considered prisoners. They are held in isolation and not given advance notice of their execution date. In Great Britain, anyone convicted of a crime is given an appeal to their sentence. If that appeal determines that one important part of the law is questionable, the case is taken to the House of Lords, at which point a death penalty would be changed to life in prison. There are no other appeals. It is ludicrous the burden the American taxpayers have to carry to protect the rights of an individual who had practiced no more restraints towards their victims. For the amount of money the taxpayers will provide for Brian Dwayne Brookins to sleep, eat, exercise, read law books, and hire attorneys for the sole purpose of having the death penalty reduced to the life in prison. Government could have reduced the national debt by $3 million, or built a low-expense health care facility for the homeless and elderly, or created jobs for the millions of people that lost their jobs due to the current economic disaster. Instead, our government and many governments continue to protect the rights of these individuals who, with a simple pull of a trigger, took away the rights of their victims and families. I hope everyone listening to this speech will contact your federal and state representatives and demand a review to change the current appeal system. Thank y'all for listening and thank y'all for coming.